arrested or anything like that because I've never been in jail. Like, I'm 23 years old. I don't want a criminal record. I haven't eaten nothing all day. That's why I'm shaking. I can't breathe right now. But I'm just trying not to have an anxiety attack. Well, he said it was 26, so if that's the case, then that.
Okay.
Yeah.
Alright.
I didn't know it was that much at all.
Okay, 1 second. Alright. I'm Detective Ehlers. I'm with the Atlanta Police Department. I'm going to read you your constitutional rights, alright? You ever been, read these before? You ever been in trouble?
No, sir.
Alright, take a seat.
No, sir.
It's alright. You have the right to remain silent. Do you understand?
Am I being arrested?
I need a verbal yes or no. I'm going to read you these.
Yes.
Anything you say may be used against you in court. Do you understand?
Yes, sir.
You have the right to talk to a lawyer before and during questioning. Do you understand?
Yes.
If you cannot afford a lawyer and want one, one will be provided for you before questioning without charge. Do you understand?
Yes, sir.
Detective Ayers opened the interrogation by reading Miranda warnings. Under Miranda v. Arizona, 384 U.S. 436, law enforcement must advise any person in custody of 4 rights before substantive questioning may begin. The right to remain silent. The right to know that statements may be used against them in court. The right to an attorney before and during questioning. And the right to appointed counsel if they cannot afford one. The detective paused after each right and required a verbal confirmation. The subject acknowledged all 4. This procedure satisfies the constitutional requirement. The waiver was express, verbal, and documented on Bodycam. However, a procedural irregularity appeared immediately. Detective Ayers identified himself as being with the Atlanta Police Department. This incident occurred in Orlando, Florida, squarely within the jurisdiction of the Orlando Police Department. While almost certainly a verbal slip, the misidentification is legally relevant. A defense attorney could argue at a suppression hearing that the subject was materially confused about which agency was investigating her, potentially affecting the knowing and intelligent prong of the waiver analysis. Under United States v. Doe, 155 F. 3rd 1070, a waiver is knowing and intelligent only when made with full awareness of both the nature of the right being abandoned and the consequences of that decision. A subject who believes she is speaking to an Atlanta detective rather than an Orlando detective investigating her own employer may later argue her understanding of the proceeding was incomplete. The practical impact is likely minimal, but it is a gap.
All right. So, tell me what's going on. Why are you in trouble today? Okay. What did that decision entail?
Helping them by refunding their money that wasn't supposed to be refunded. And then they kept coming, and then I also felt peer pressure in the situation to not do it anymore. And, you know, I didn't stop it, whatever. And morally it's wrong. It's against my, you know, I don't want to do that. I've never been in trouble before. I told Ricardo I'm very sorry. You know, I love my job. I pleaded for my job, but that's not the case anymore. But I just didn't want it to get further of me getting in trouble or anything like that, you know. I'm willing to do anything that I need to do. I just don't want to be like arrested or anything like that because I've never been in jail. Like, I'm 23 years old. I don't want a criminal record. I don't want to go down that route from, you know, putting myself in a situation that I shouldn't have been doing. I haven't eaten nothing all day. That's why I'm shaking. I can't breathe right now. But I'm just trying not to have an anxiety attack. I'm very apologetic for the situation. I just want to leave.
I understand. Listen, I understand that, you know, being in this situation is going to be, you know, cause you anxiety. I mean, anybody in your situation would feel the same way, okay? So, I want you to take some deep breaths. Just try to relax, all right? I'm going to talk to you like a normal person, all right? I know, man. Listen, I understand, you know, especially with what's going on, all right? I get it. So, we're going to do our best, okay? All right. So, how did this first start?
Well, apparently he said it happened in June, but the person came into the park with some tickets and wanted to refund it. I refunded whatever, and then it just became a habitual pattern.
So, who's this person to you?
She's from Tampa. She's a friend, like old childhood friend or whatever. And like I said, her mother was sick and stuff like that, so I just wanted to help her out. That's all it was.
So in the beginning, when you first started refunding, did she know that you worked here?
Yeah,
Okay, so she came to you specifically for this?
Yeah, she had to.
All right. Did she ever say where she got the tickets from?
Nah.
Okay.
Not
How
the
many
first
times? Not the first time?
No.
What about the other times?
The other times, yeah, it was for me. Like I told you.
Okay, so there's only one occurrence where she showed up with tickets. The rest of the time was you using other tickets that were canceled out, or where did those come from?
So it wasn't that they were canceled out. It was like tickets that I would find, like I said, on the ground and stuff like that, or old tickets and stuff like that.
So like a discarded ticket from somebody who already paid admission, or how does that work? What do you mean you just find them?
Yeah. So like a discarded ticket that I already used.
Okay.
Yeah.
So this person that you're giving money to, they have health issues, or their family does?
Correct.
What's going on with that?
It was, like I told her, that it was chemotherapy.
All right. How long has this been going on?
Well, he said since June.
Well, how long has it been going on?
Since June.
Okay, well, don't say he said since June.
No,
you know.
I didn't know. He asked me the first time. I didn't know what month it started. I don't remember.
Yeah.
I just know it was that long. It was recent.
I'm trying to get your side, man. I know what they told me, so you know what I'm saying? I get it. So it's been going on since June.
Mm-hmm.
All right. When you're refunding money, are you getting money in return?
They give me the money in cash. She would, like, whenever I seen her, she would give me some money.
She give it you in cash?
Yeah.
Any other ways?
It was like Cash App a few times.
Cash App?
It was cash.
How much you get? Roughly.
I
Ballpark
told him less than 2,000. It wasn't that much. It wasn't the whole thing.
It wasn't?
No.
So when I pull your bank account, I'm going to see less than 10 grand in there, or I'm going to see more than 10 grand in
You're
there?
going to see less. It's not in there.
All right. What do you do with it? You don't put it in the bank? You pay the bills?
With the cash. I mean, cash.
Well, when you get the cash, you get a lot of places aren't going to, depends on where you go, I guess, to pay the bills with.
Yeah, I would go to Amscott. Yeah.
Amscott, okay. All right. Well, let's see. I mean, this is wrong. I mean, I understand helping somebody out, but did you not think this was gonna?
I did. That's why I felt like it was just. I felt like it was gonna sneak up on me and come back at me, bite me in the ass, which it did today unexpectedly. And I'm just like, when I first did, I didn't want to do it. I just felt so bad. It's like, I don't like to risk my job because I'm in Orlando. I live by myself.
Yeah.
I'm a college student. I've been doing everything on my own. Like, my family's in Tampa. I try to support them too, and they try to support me. Like, I have a lot of pressure on me. I'm the oldest of four. I don't get in trouble. Like, I'm an actual good person.
Yeah.
And when I did it, I felt bad. Like, I just, wish I could erase that first time.
Well, to say that you're an actual good person, I mean, people make mistakes. So I'm not judging you based off this situation. I don't think anybody else has, the right to judge you off this situation. Obviously, there's external factors in here. You made a mistake, and people make mistakes every day. Unfortunately, there are consequences to this one. If you had to guess roughly how much money between you and this other person, what are we talking here? Ballpark it.
Like I said, less than 10 grand.
Less than 10 grand that you got, or less than 10?
Got.
Okay, so how much do you think they got out of this?
Well, he said it was 26, so if that's the case, then that.
Okay.
Yeah.
All right.
I didn't know it was that much at all. It didn't.
Well, I mean, it's been going on for a couple months now.
It was a couple times, but I guess of the amounts, it was like $1,000 each time or something like that. That adds up. But
you know how expensive it is to get into Universal. I mean, you know what I'm saying?
It's just that number sounds big,
It does sound big. It does sound big.
That's not believable to me.
Now to the voluntariness question, the most significant legal issue in this footage. The subject stated she had not eaten all day. She described shaking, difficulty breathing, active anxiety, anemia, and inability to feel her fingers in a cold room. These are not trivial conditions. A defense attorney would argue they raise serious questions about the voluntary nature of her subsequent admissions. The governing standard comes from Colorado versus Connelly, 479 U.S. 157, decided in 1986. The Supreme Court held that coercive police activity is a necessary predicate to finding a confession involuntary. under the Due Process Clause of the 14th Amendment. Internal psychological pressure, standing alone, is insufficient. The detective here did not exploit the subject's condition. He offered paramedics, he encouraged deep breaths, he kept his tone calm. Under Connelly, the absence of police overreaching means the subject's confessions are almost certainly admissible. However, the totality of the circumstances standard still applies. Courts examine the interaction between the subject's vulnerability and the interrogation environment, including room temperature, duration of detention, and denial of basic needs. The subject's admissions were extensive. She confirmed approximately 20 fraudulent transactions beginning in June of 2021. She described the mechanics, processing refunds against discarded tickets, with no underlying customer, in exchange for cash and Cash App payments. She estimated her personal proceeds at less than $10,000. The detective disclosed the total loss to Universal Studios: $26,000. That figure is the anchor for both charged offenses. Let us examine each charge under Florida law.
I don't feel like I even.
How many times do you think you've done this kind of transaction?
I would say about no more than 20 times.
Okay, so let's just say that 20 times, tickets are what, over $100 now? You multiply that by 20, we're up there, you know what I'm saying? Like, you're getting...
That wasn't crossed my mind at all.
Yeah.
That would be that.
I'm sure it wasn't, because
I didn't even think it was.
You're trying to help somebody out who's in a difficult situation.
I didn't even think it was. I honestly didn't know. Like, I didn't think it was the one. He read the numbers. This was like a slap. Like, whoa, like, are you serious? Because I didn't.
Yeah.
Had I known, I would never.
How long are we going to keep doing this if we didn't get caught?
I'm never going to do this.
No. That's not what I'm asking.
Oh.
I'm asking you, like, obviously you got caught, but what if she came in tomorrow and, are you going to do it again? I mean, how many...
I wasn't, because, like, honestly, I haven't been able to sleep because I felt bad. Like, I literally was going to stop. Like I said, this whole time, like, the other time, I felt like I was peer pressuring into doing it because it's like, if I'm not helping her out, the mother's gonna die. Like, you see what I'm saying? So it's like...
Well, let me ask you this. Is that your responsibility?
It's not.
Okay. I understand you're trying to do the right thing, and it's admirable that you're trying to do the right thing.
That's why I'm in this job, because I help people, So I try to
that.
help people. That's the type of person I always love to help people. But I know that I can't risk myself, or, I have to do it the right way.
Right.
And that's how I was raised. And, like, for me to be in a situation, like, my grandma would go crazy. Ass, right? She's the one that raised me. She's a single grandmother raising me, and I'm in some trouble like that. That's heartbreaking to her. For her to even know I'm in a situation like this, I don't even want her to know. Like, I'm scared to tell her. Like, I just know it would break her. And she's 73 years old. Like, I just, I feel horrible.
All right.
I can't believe this. We got this far.
All right. Well, we're gonna wrap this up and figure out what's gonna happen. All right.
Okay.
So I appreciate you talking to me. I appreciate your honesty.
What's your name, sir?
Under Florida Statute Section 812.014, grand theft is classified by the value of property stolen. Property valued between $750 and $19,999 constitutes a third-degree felony up to 5 years imprisonment. Property valued between $20,000 and $99,999 constitutes a second-degree felony up to 15 years imprisonment. At $26,000, this grand theft charge is a second-degree felony under Florida law. The scheme to defraud charge is governed by Florida Statute Section 817.034, the Florida Communications Fraud Act. This statute defines an organized scheme to defraud as a systematic, ongoing course of action to intentionally obtain property through false representations. The penalty thresholds mirror the grand theft statute. Below $20,000, third-degree felony; between $20,000 and $50,000, second-degree felony, up to 15 years imprisonment and fines up to $10,000. At $26,000, the scheme to defraud charge is also a second-degree felony, the same tier as the grand theft charge. This creates a double jeopardy issue worth flagging. Florida courts have held that a defendant may not be simultaneously convicted of both organized scheme to defraud and grand theft for the same underlying transactions. The Florida Supreme Court has recognized that scheme to defraud subsumes grand theft as a lesser included offense. In practice, the state must elect the stronger charge or proceed to trial on the theory that the jury convicts on only one. A competent defense attorney would file a motion to dismiss one count as duplicative and would likely succeed.
Detective Ehlers. Yeah, here. I'll give my business card. Don't let the business card fool you, alright? It's not why I'm here. Okay? That's what my normal job is. This is not. So, it says violent crimes. This is obviously not a violent crime, alright? So, just hang out. Hopefully it won't be too much longer and we'll wrap this up, alright? Again, like I said,
have to sit in this room. I can't function. It's really cold in here.
It's cold in here?
I'm anemic.
You're anemic?
I can't feel my fingers right now. That's why I've been asking him, can I go outside?
Well, obviously, you know, they would rather have you not roaming around the property. You know what I'm saying?
I will literally sit on the bench right there.
So, I understand that.
It's
But
really cold. I can't.
yeah.
And I haven't ate shit. Like, I'm just feel weak.
Do you need the paramedics to check you out or health services?
That's not gonna help.
Just gotta ask, you know.
I know.
I know it sucks, but you know, just try to bear with it a little bit longer, okay? All right, man. I'll be in the next room if you need anything. All right.
Go stand up one real quick. Hands on your back. Okay, let go of your phone, alright?
I'll grab it.
Put your pants back in the sandwich like that, alright? Put your arms back a little bit. Get your breath so it's not too tight, is it? Alright. Alright, check it out real quick. He's going to explain to you what the charges are, but you're already placed under arrest. Do you have anything illegal on you?
So, because of the serious case of this nature, you're being placed under arrest for grand theft and scheming to defraud. All right, these are both felonies. You will have a bond. Okay. The best case for you is just keeping honest, just like you've been doing, and then we'll see where it goes from there. But you know, hopefully, I know you had good intentions, man, but it's still theft. All right, and it's a large amount. Okay. So this officer is going to transport you to jail, and at that point you'll be able to get processed in and be able to make your arrangements for bail if you can. Okay. Is there anything in your pockets? No.
Alright, I'm going to check you real quick. Nothing's going to poker stick me, right? No guns, knives, needles. Perfect. We'll do it in here so we don't live in longer in the parking lot, okay?
There's some gas and chapstick.
Okay. Everything that's on you is going to go with you. I'm just going to take it out here.
My stuff is in there though.
What stuff?
My keys and stuff in my bag.
Where's your bag at?
Inside the locker in guest services office.
Okay.
It's the second locker all the way to the.
How'd you get here today?
I drove.
Okay. That's gonna be all right. Let me find out how logistically we can do this because it may be able to stay in there. You're gonna have to come back and get your car eventually. So I don't think they're gonna tow it or anything. So all right. So he's got stuff in the locker and he's got his car on property. How do y'all want to handle that?
We can get his stuff from his locker, and then the car you can pick it up whenever.
Okay.
Whenever you get time.
All right, that's fine. Yeah, we'll get your stuff before you leave, and that'll just come with you, and then your car you can make arrangements to come back.
Can you spread your feet real quick for me?
Does he know which locker it is?
Which locker is it?
Okay, so there's two lockers. It's the right side locker. It's the second locker from the top row.
Spread your feet a little more for me.
It's an army fatigue bag.
What locker is it?
It's an army fatigue bag. It's the second locker all the way to the right on the second row from the top.
The second row from the top. An army fatigue.
Yes, the locker all the way at the end, the second row to the top.
Second row to the top. Okay.
Leave that mask in that. What are these?
So let me go see.
What's up, man?
Anything else in here?
Yeah, this one. It's scheming to defraud and grand theft. So yeah.
Now the grades. Detective Ayers receives a B+. His Miranda advisement was complete and properly documented. His rapport-based interrogation technique was effective and legally sound. He proactively addressed the subject's medical distress, reducing the risk of a voluntariness challenge at suppression. The deduction comes from one source, identifying himself as being with the Atlanta Police Department during an OPD investigation. In a custodial Miranda context, every factual statement made to a suspect before questioning begins is subject to legal scrutiny. Accuracy in agency identification is not a technicality, it is part of the knowing and intelligent waiver analysis. The subject receives a C+. She waived her Miranda rights without invoking counsel, facing 2 second-degree felony charges with a combined maximum exposure of 15 years. She then provided detailed, unprompted admissions covering every element of both offenses, timeline, mechanics, payment method, transaction count. Her cooperation may serve her in plea negotiations. It has effectively eliminated every viable legal defense she might otherwise have held. The C+ reflects her non-resistance during arrest and her genuine remorse, both of which carry weight in sentencing. Before we close, 3 practical lessons this footage illustrates. First, invoking the right to counsel is not an admission of guilt. It is the single most protective act a person in custody can take. The moment those words are spoken, I would like an attorney, all questioning must stop. That right existed here and was never used. Second, the double jeopardy issue here was built into the charging decision. Law enforcement and prosecutors must ensure that parallel charges arising from the same transactions are not facially duplicative. At the time of arrest or risk having one count dismissed pretrial. Third, Miranda accuracy matters. Every word spoken by a detective before questioning begins is part of the legal foundation on which that interrogation rests. A misidentified agency is a crack in that foundation. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.